So eligible employees for pregnancy and maternity leave are entitled under Ontario law to a number of things. The two most importantly being that when they return from their leave, that they'll be given a similar job or that the person that they had before their leave, or a comparable job if they're not able to get the similar job. And that's a right that they have under the Employment Standards Act. The time off for pregnancy and maternity leave isn't required to be paid by your employer. Employment insurance covers the time off for maternity or pregnancy leave. Employers can top up that time, so they can pay up to the maximum, up to what you were making before, if they want to, but they are also allowed to put conditions on that. So many employers, when they do that, they put a condition on that the employee has to continue working for some amount of time afterwards, 1 year, 2 years or so, given the top up to be able to recoup the investment that they make. Employees, if they are terminated for taking paternity, maternity, or pregnancy leave, are protected under the Human Rights Code on the basis of gender and family status. And so if an employee is terminated during that time or discriminated against for taking those leaves, then they're protected under the Human Rights Code and can seek remedies through that or through the courts using the Human Rights Code. While there is the right to have the same position, and it also is discriminatory and against the Human Rights Code, it is possible for employers to have bona fide terminations. Let's say a whole department is being shut down. They aren't required to give you a job if your job isn't there. So it is possible. However, very often when employees are terminated, when they're on pregnancy leave or maternity leave, we've found that they're often selected for that because they just aren't there at the time. And so it's very important that if someone is laid off, generally those employees are entitled to substantial notice periods, which means that they should be contacting an employment lawyer and making sure that they get adequate compensation from their past employer. If an employee is terminated based on taking a pregnancy or maternity leave, they are entitled to reasonable common law notice, so an elongated notice period. Generally, this would be further elongated because it's going to take them longer to get back into the workforce. It's going to be more difficult. They're going to have a young child. The child's going to have a difficulty in terms of getting into daycare. They're in a different position than many other people who are applying for jobs. And so it's important to make sure that they're fighting and not being compared against other people who aren't in a similar circumstance. As well, the employee might well be eligible for human rights damages, so the employer paying or calling some of the amount of notice human rights damages, which would be general damages, which would be payable to the employee for breaches of the Ontario Human Rights Code.